Hi everyone. I guess we'll be starting now. Thanks for coming to our talk. So it's titled IP Securing and Protecting Intellectual Property Rights. So we are lawyers from Media Arts Lawyers. I'll let Amanda introduce herself just to give a bit of background.
So I'm Amanda Mason. I'm a senior lawyer at Media Arts Lawyers. I work across various fields: commercial, IP, gaming, entertainment industry, defamation.
And I'm Isabel Wang. I'm a lawyer at Media Arts Lawyers. And we are primarily a general service firm, where we do a lot of different types of law and different areas that we work in. But our main interests or our main industries are in creative industries, including gaming, but also music, music rights, licensing, and all of those other elements as well. So that's a little bit about us. So we'll just jump straight into the talk, I guess. Great. So today we'll be going through some key elements of intellectual property, giving a little bit more of a definition, and then from there we'll be describing why it's of interest and where it might apply for you and any projects that you're working on. So the first thing to clear up is, what is intellectual property? I feel like most people now have a pretty good understanding what intellectual property is, especially in this day and age where everyone is dealing with, properties and rights day to day on social media. So a quick summary is that intellectual property is an intangible property created by the mind or intellect. So anything that comes out of your mind is intellectual property, basically. So the owner of the intellectual property or certain rights of IP is the person who creates it, generally speaking, but we'll go into ownership a little bit later. And some rights are automatically given, such as copyright, whereas other rights can be registered, such as trademarks, patents, and designs. So we've got little circles here that just sort of summarize what elements could be IP. So copyright, typically speaking, artistic creations and whatnot. Trademarks, a lot of branding elements can be there, such as logos, titles, even phrases. We'll get into that a little bit later. And then patents as well, typically speaking, inventions, innovations and whatnot. Part of IP as well is registered designs, which fall close to patents, but we are going to go over patents and designs fairly lightly today, because the main interest, I feel like, for a lot of game developers is typically copyright and trademarks.
So these are some examples of IP in games. So under copyright, there's source and object code, music, so both the composition and the sound recording, dialogue, script, artwork, character and object design, game engines, GUI, studio name and logo, game title and logo, character names. Sorry, this is in trademarks now. Studio name and logo, game title and logo, character names. And then patents would be things like game consoles, controllers, and certain type of software, provided that it's, inventive or innovative.
So as you can see, there's a lot of different types of elements that can be IP. The first part we'll really break down is copyright, which is, so where does copyright really apply? And the answer is works. Any type of work that you see listed here, artistic, literary, dramatic, musical. I think everyone is probably fairly aware of these elements that have copyright, but also additionally you can have subject matter other than works, which are films, sound recordings, broadcasts and published editions. So copyright is quite broad and pervasive in whatever you really do and whatever you can really create. And it's a really good way for artists a good thing for artists to understand and how to protect and commercialize their rights.
So for games, there's no specific copyright protection for the game as a whole under Australian copyright law, but it's generally made up of different components that receive the protection. So for example, source code is considered a literary work, graphics is considered an artistic work, music is either a literary work for the lyrics, a musical work for the composition, or a sound recording for the recording of that composition. Sound effects are a sound recording, and moving animated aspects are film. So the protection in Australia is automatic for copyright, but other countries have copyright registration systems. For example, USA, Korea, or South Korea specifically, Japan and China. So copyright grants the owner certain exclusive rights, which vary depending on the type of work. Oh, sorry, this is your slide. I'm already stealing it from you. No, you can have it back.
Yeah, so I suppose to rehash, it grants the owners specific exclusive rights, specifically the ability to reproduce the work, publish the work, perform the work in public, and also communicate, cause a sound recording to be heard or seen, make an adaptation of, which is very key for any cross-media developments, and also to make a copy of the sound recording and film. So because there are different types of works, there are also different types of exclusive rights that may be afforded to that type of work. If you're thinking about artistic works, such as images, stills will be artistic works, photographs, literary works, which could be script and dialogue. Generally speaking, their exclusive right protections are to reproduce the work, to publish the work, and to communicate the work to the public. Whereas sound recordings, as you can see, there's some specific ones there. So cause a sound recording or film to be seen or heard in public, make a copy of the sound recording or film. So while the exclusive rights, they are slightly different for each work, they generally protect the same thing, which is that, as the creator or the person who owns the copyright, you have exclusive rights that you can elect to use or not use. A quick note on the duration. So copyright does expire, essentially. There's the concept of public domain works now is fairly well known. For example, Winnie the Pooh, some iterations of it is in the public domain. So duration now is pretty important because a lot of the IP that we're familiar with now are reaching that 70 years after the death of the creator mark, and the sound recordings and films is generally 70 years after the material was first made public.
I do have a question. Why then did the first works of Mickey Mouse enter the public domain recently? Because Walt Disney only died not quite 70 years ago.
I'm not too sure of the history but the question is also who the actual creator was. So I'm not sure if it was Walt Disney only or if there was a creator earlier that has some sort of ownership over that. But what we're really looking at when it comes to duration is the creator and if that work has been assigned or not.
And here we're also talking about the Australian copyright laws, so under the US copyright laws it might be slightly different to here as well.
Yeah, I suppose a quick caveat we should give throughout the copyright section in most of the talk is this is Australian law. The good thing about intellectual property, though, is that there are a lot of treaties and stuff and adjacent documents that make it similar across different jurisdictions, but for the most part, this will all be Australian-focused and Australian-centric.
So copyright protects the expression of an idea rather than the idea or the underlying concept itself. And to sort of give you an example of how this works, it's a US case, so under US law, but the principles still are similar. So there was a case between Midway and Bandai, and as part of that case, it was considered whether Galaxian had copied Space Invaders and was an infringement of the Space Invaders copyright. But the court said that the only similarity between the two is the idea of the underlying games, i.e. outer space games where a defendant base or rocket ship controlled by the player attempts to fend off attacking hordes of aliens. And where the expressions of the Galaxian and Space Invaders works are compared, it's clear there's no similarity beyond that of an idea. And even if Midway had copied the idea of Space Invaders game, this wouldn't comprise a copyright violation. So that kind of demonstrates to you that the idea, because these two games do seem quite similar, but it's only the underlying idea rather than the expression of the idea that really have the similarities.
Which one was Space Invaders and which one was the other one?
For those of you who are not as old as I am, the bottom one is Space Invaders and the top one is Galaxian. And so sort of contrasting to that, there's also a more recent case between Tetris Holding and Zeo Interactive. So Zeo argued that its game, which is called Mino, which is the one on the right, only copied the idea of Tetris and not the expression, and because the idea is not something that can be copyrighted, they were arguing that they didn't infringe the copyright, but the court held that there was copyright infringement and the following things are expressions of the idea and protected by copyright. So the style, design and shape and movement of the pieces, the dimensions of the playing field, the display of the next piece to fall, and the appearance of squares filling the game board when the game is over. So you can see from these images that they're basically exactly the same other than some sort of slight stylistic differences.
So as we mentioned before, there's a couple different types of intellectual property, and there's a lot of different ways that you can protect your intellectual property as well. After copyright, there is also trademarks, or in our presentation at least, it's after copyright. Trademarks are a mark or a sign used or intended to be used to distinguish goods or services and trade for the goods or services of others. So that's very legal and very complicated, but essentially what trademarks are meant to be a sign or a marker of someone's sale of goods. So trademarks are a registrable right in Australia and for most of the world. And so we have a trademark register and whatnot, and so you can apply to get a registered trademark. So trademarks can take on the form of a lot of different forms. The most common ones are words and logos and images. I think most people would recognize those elements of branding. Brand names, brand logos, we've got a couple of examples there. And this also includes like phrases. So if you've got like a statement or a tagline, Sony's classic one is "Play has no limits." That can also be trademarked. There's also different other types of trademarks which are slightly more unusual and that require a bit more effort to get. But because a trademark is meant to represent someone's reputation or a brand's reputation, if you've got enough of a reputation, you'll be able to trademark things like colours, for example, Cadbury Purple, or scents, which is definitely a harder one if you want to register it, but it is possible. All of these trademarks here are actually on the Australian Trademark Register, so they exist, and people have managed to register them, but the most common ones are typically logos and images. So as noted, in Australia, the trademark can be registered, but it can also be unregistered. So that's a recognition of your rights to a reputation in a trademark that isn't on the trademark register. So registered trademarks do get some straightforward exclusive rights protections under the Trademark Act. Examples of that is to use the trademark in respect of goods or services. So trademarks, when they're registered, need to apply to certain goods or services. So you will carve that out in your application. If you want to apply for a trademark for your game studio, for example, it might be class, off the top of my head, 41, which could give, creative studios like that type of service that you're providing, creative consultancies, game development consultancies, that kind of thing. And that's what you'll receive protection for. So from there, you can also authorise, assign or license the trademark for others by use. Usually this can come with a form of commercialisation. This licensing is a great way to commercialise IP. We'll touch on that a little bit later, but trademarks are a great way because it's a registered asset and it's seen that way on, profit and loss sheets. And then you can also take legal action for trademark infringement. So if someone infringes your trademark or uses it in the same classes and you own that registered trademark, you may be able to seek legal action and recourse from infringement. So unregistered trademarks I'll touch on briefly because it is an interesting system that exists in Australia. It doesn't exist everywhere, but in Australia you can still enforce unregistered trademarks, but it depends on it depends on a couple of different areas of law. One of which is misleading and deceptive conduct under the Australian Consumer Law. This is a very legal sounding thing, but it's quite simple in that you can't deceive or mislead consumers into thinking that they're buying from a brand that they're not. It's the most simple way to think about it. And similar to that, passing off is the same. You can't, again, deceive or pass off someone else's goodwill, brand and reputation for your own when it's not yours. Otherwise, there's also copyright infringement that can be included in sort of that active brand protection strategy for unregistered trademarks. So there's a couple of different ways you can approach it, but for sure the registered trademark system is really, really helpful for anyone who wants to build a brand and looking to commercialise a game or project further.
So we'll just briefly touch on patents because we think this is probably less likely to be of interest unless any of you are making hardware. But you can have two types of patents. You can have hardware patents. For example, the PlayStation DualSense controller is a hardware patent that is registered by Sony. The NES is a patent that Nintendo has. And then software patents are much less common, but an example of one that Microsoft has is a graphical overlay for streaming games designed to be used with controllers on a touchscreen device. So that's quite complicated. But basically, patents protect devices, substances, methods, or processes that are novel, inventive, and useful. It grants the owner exclusive rights to exploit the invention and authorise someone else to do so. So that's quite similar to copyright and trademarks as well. It's shorter duration. The duration is 20 years for a standard patent or 8 years for an innovation patent.
So the big question, I think, for most people is who owns it? Who owns the intellectual property? We'll mostly be talking about copyright in this instance because for registered rights, you register an owner, so it's quite clear for the most part. But simply put, in copyright, if you made it, you own it, and except for some exceptions. So as lawyers, we give you an it depends a lot, and this is one of the first ones. So copyright is generally owned by the person who makes it, subject to the following exceptions. If you are a person, you create the copyright, but you want a company to own it, for example, you will need to assign it or, trade it to a different entity, license it. If you're an employee and you've created copyright in the work under employment and with employee materials and whatnot, the employer owns it. And that's quite an important one for a lot of studios and also freelancers as well, to know where your copyright starts and where it ends, especially if you're working in a similar industry with an employer. And then if it's a photo, portrait or engraving, if it's commissioned and it's for domestic use, then the commissioner owns it. Now, the reason why we've included that final dot point is to distinguish this from the US regime of work for hire. A lot of people are familiar with the concept of work for hire. This is actually a US regime where if you are commissioned for the work, then the commissioner owns it automatically. In Australia, the commissioner owns it in this specific instance, otherwise it needs to be assigned in writing. So that's something to highlight because we find that a lot of our clients and game studios and whatnot will come to us under the assumption that work for hire has occurred and that they own the works. But if you're in Australia, you need to do a little extra step, which is to put it in writing.
Is that per piece?
Per copyright, yes, per piece. Or you can have an extended contract type of thing. So as I mentioned before, registered trademarks and patents are generally owned in accordance with the registered details. That's the positive of a registered intellectual property right, is that it's very clear, it's on the register, the owner is the person that's stated right there.
So now we just have some example scenarios. We've done it relevant to game developers because we think that's probably what most of you are doing. But so, for example, an employee hired by a game developer creates copyright in the course of their employment, then the copyright owner will be the game developer unless there's an agreement to the contrary. If a contractor is engaged by the game developer and creates copyright as part of that engagement, then it's usually the contractor unless otherwise agreed. So that sort of shows you the distinction as to if you've got a contracted employee, you're probably all right for copyright, but if you've got a contractor, not an employee, then you'll need to have an agreement, or your agreement with them will need to specifically confirm that the copyright is to be assigned to the game developer. If the game developer commissions and pays for the creation of a sound recording or film, then it will be the game developer unless otherwise agreed. If the director of the game developer company, so in this sense it's a director as in the person who's the director appointed to the company, not a film director or a project director. In that case, if the director creates copyright work for the company, which is often the case if a small team incorporates a company, the director will be creating the work, doing a lot of the work. The director will actually own that copyright unless otherwise agreed, or if the director is an employee, then it'll fall under the employee scenario. Similar to director of the company doing work for the company, if a shareholder of the company creates copyright work, they'll also own the copyright work unless otherwise agreed, for example, in a shareholders agreement or any other sort of assignment of copyright, or if they're also in employment and then they've created that copyright in the course of their employment. But in a lot of cases with smaller developers, a shareholder might be doing work for free or to receive dividends from the profits of the company as opposed to receiving a salary like an employee, so they may not be an employee.
So the big question is also, why do you need to own it or control it? I think that we've alluded to this throughout most of the talk and the whole concept of it, but the couple key elements is to avoid legal claims for IP infringement. So if you own it or you control the IP or you have a license to it, generally speaking, it means you have the rights to use it, where you need to use it accordingly. So that's a big one, number one. And this also flows into the next point, is that many agreements, for example, publishing, development, grant agreements as well, will involve a licensing or some sort of acknowledgement that the IP is owned by you or it's licensed by you so you can utilise it. So we'll touch on this in the next few slides, but such agreements might ask you to make warranties. or indemnify the other party, which will affect, these are commercial terms that might affect the way that you commercialize your work. Finally, it's also just a valuable asset to be clear of who owns the IP. IP is considered an asset. Different types of IPs are considered differently. But in summary, if you want to, sell it or license it for cross-media exploitations, we've got some examples: The Witcher, Fallout, The Last of Us, all of which are really now popular IPs across different areas of media. If you own that IP, you're able to license it, which means you're able to commercialize it. So basically, if it's an asset, you can sell, license, or otherwise commercialize or receive income or funding from it.
And so we just briefly touched on warranties, but what a warranty is. So you'll find many agreements that involve the license or assignment of IP will require the party that provides the IP to provide a warranty. And so the warranties will be that the person has obtained all necessary IP rights, the IP doesn't infringe the rights of any third party, and the use of the IP by the counterparty in accordance with the agreement won't infringe the rights of any third party. So in order to be able to make those warranties, you need to ensure that you have the IP or you control the necessary rights, whether you own them through assignment or you've licensed them. But if you don't have all the necessary rights tied up, then you won't be able to make these warranties without breaching them as soon as you enter into the agreement. So as an example, the types of agreements that include these types of warranties, so distribution agreements, so e.g. distribution on Steam, PlayStation, Xbox and Nintendo stores. Publishing agreements will almost always include these types of warranties, and then also various other agreements that grant IP rights, so merchandise, film, TV shows, books, graphic novels. Nearly every type of agreement that involves the license or assignment of IP will include a warranty like this. And so here we've got a little example of a warranty clause. So I'll just sort of briefly run through this, but most warranty clauses are pretty similar in structure and will look very similar to this. So we've sort of drafted this as if it's a publishing agreement, but it provides that the developer warrants that it holds all rights, including IP rights, in the game materials necessary to grant the publisher the rights under the agreement. The game materials do not infringe the rights, including IP rights, of any third party. The use of the game materials by the publisher in accordance with the terms of this agreement will not infringe the rights of any third party, including IP rights. So in this context, game materials, you'll see it's capitalised, and that's because we do that quite a lot in legal agreements, and there will be a defined term of what game materials are, but usually that will be whatever it is that's being licensed to the publisher. If it's source code, it'll be source code. Otherwise, it'll be the game. It'll be potentially the ability to use the trademark, some other promotional materials. It could be bios, it could be photos, it could be various designs, logos, etc. So ultimately, if you don't hold the rights, you can't make this warranty without breaching the agreement. And so sort of flowing on from the warranties is indemnities. So an indemnity is agreement to cover the loss and damage of the other party. And so normally at law, if you breach a term of an agreement, the sort of general position is that the loss that the person can claim is limited to certain types of losses. So for example, if the loss is too remote, the court won't allow that to be recovered. It'll only allow certain, more obvious losses that stem from the breach of the agreement to be recovered. Whereas if there's an indemnity in the agreement, that extends the liability to include those sort of remote losses as well, so indirect and sort of remote types of losses, less likely to be predicted at the time of entering the agreement. So an indemnity will usually relate to loss or damage caused by specific things, for example, a breach of the agreement, a breach of the warranties, IP infringement, or negligence. And so this is an example of an indemnity clause. So I've sort of underlined and bolded the things that are that I want to attract your attention to. But it provides that the developer will indemnify the publisher against any loss, cost, charge, liability, or expense which the publisher may suffer or incur as a direct or indirect consequence of any breach by the developer or its personnel of any of its obligations or warranties under the agreement, the infringement or alleged infringement of any third-party intellectual property rights in the game, or any negligent act or omission or willful misconduct of the developer in connection with the performance of its obligations under the agreement, except to the extent that any such loss, etc., is caused or contributed to by the publisher. So what this basically means is in A, if the warranties are false, in addition to being able to sue you for a breach of contract, the publisher will be able to sue for a full indemnity. So they'll be basically seeking all the losses, costs, charges, claims, liabilities, and expenses they suffered either as a direct or an indirect consequence of those warranties being false. And B is similar, and it relates to an infringement or an alleged infringement of any third-party IP rights in the game. So it sort of demonstrates that your liability can be more significant if there's an indemnity clause, and therefore you really want to make sure that you can make the warranties so that if you have to provide the indemnity, you're confident that at least you can provide the, points A and B on this confidently.
So that's probably a lot of information to take in at one time. I want to bring it back to something that feels a little bit more relevant to sort of the day-to-day, being that another reason and that incorporates warranties and indemnities that IP is important is for grant applications. So right now, Australia's got some really excellent grant opportunities and funding opportunities and whatnot. And at the bottom there, we've got some just key bodies. I'm sure everyone's very familiar with them. But the IP is important when it comes to grant applications, because typically grant applications will be asking you to make those warranties, similar to what Amanda just described. And they will also ask you to confirm a chain of title, or at least receive advice for chain of title. So that's usually where the lawyers come in, and we will give a solicitor's opinion, or you might need to confirm that you received solicitor's advice. So what is chain of title? Do you mind? What's the thing?
Sorry, do you want me to switch?
Yeah, I put it in my pocket. So what is chain of title? Chain of title is inherently connected to IP and property and whatnot, but in summary, it's a series of documents, generally speaking, that proves ownership to any underlying material in a project. And that project can be a game, it can be a film. Chain of title clearances also occur for films in relation to any intellectual property, including copyrights, trademarks, Indigenous cultural intellectual property, and moral rights. So there's a lot of different rights involved there. We've just put a little example here, being that Jane develops a game. The game incorporates different types of IP created by both third parties and contractors. And then once it's developed, they want to incorporate a company associated with the game that transfers ownership to the game to the company. And then as part of a grant application, Jane might need to establish the chain of title, and the company owns all of those elements. And therefore, funding can come because it's basically, there's lower risk for funding that type of game. So in this case, Jane needs to assign her IP in the game to the company, because she as the individual may have created it, but the company is a different legal entity. And then all third parties who own or control IP included in the game must then also assign it or grant a license so the company can exploit the game. And then all contractors must have assigned or at least clarified their rights, that the rights are now owned by the company, so the company can commercialize it. So chain of title is essentially making sure you've got all the documents in order to show that the company or whatever entity that is receiving funding actually has the rights to commercialize the game or exploit the game or any project, so that the funding goes to the right body.
So now you know why you need to have the necessary IP rights. How do you actually make sure that you do? So step one is keep detailed records of all IP used, including original and third party. And I know that some devs are pretty stringent at keeping those kinds of records, but others will just sort of, use third-party software and not really keep great records of which particular ones they've used, because ultimately you need to confirm that the license rights of that third-party software allow you to do what it is that you need to do. You ideally want to have NDAs in place in the early stages to protect confidential information. And that's again because we talked about before that copyright only protects the expression of an idea, not the idea itself. So if you're at the stage where you only have an idea and you haven't expressed it in a way that's protected by copyright, then that's not protected by copyright, but you can protect that by an NDA instead. Ensure you have written agreements in place with creators and controllers of all IP used that either license the IP rights or assign the IP rights. And either the assignment or license needs to be sufficient to allow you to use the IP as you intend to. So it's preferable to have an assignment of IP rights that lets you do whatever you want with the IP that you've acquired. But in some circumstances, for example, third-party software, you'll never get an assignment, you'll only get a license, but you just need to make sure that the scope of the license is broad enough to allow you to incorporate that IP into your product and then distribute and exploit your product as you're intending to do. So then that kind of leads us to, what about open source? Can you use open source? Yes, you can, but there are some things that you need to consider. So it really depends on the term of the license granted for the open source, but usually it will allow you to use, modify, and distribute that modified work, which is all of the things that you most likely want to do with it. However, you need to be really conscious because copyleft licenses, for example, GPL and AGPL, will generally require any derivative work that incorporates the open source work to be offered on the same copyleft license terms. So that means you basically have to offer your new software that incorporates this software for free, or perhaps not for free if that's not what you acquired it for, but generally you have to make it available. It also generally requires the source code of the derivative work to be made available to the public. So if you don't want to make your source code available to the public, you definitely don't want to include any copyleft open source software in your product. This is kind of contrasted to permissive license. So for example, MIT and BSD, they're not usually subject to the above requirements. They'll have some other requirements, like usually you have to credit and certain things, but copyleft are the ones that you really need to be careful for.
So what about generative AI? We've included a chat about AI mostly because it's an increasing area of like platform use, but it's still very much so a developing area. Right now, all of the laws that currently exist still do apply, but there's some, there's regulations and whatnot that are changing in the world. So Australia is still pretty straightforward when it comes to laws, but regulations are happening everywhere else all over the world, and it's becoming a more globalized concept. This is a summary of OpenAI's terms of use and business terms. So those specific terms of use provide that users retain ownership of the input and the output is assigned to the user, which means that you own the IP that you put in and the IP that comes out will be later assigned to you, meaning it's not actually automatic, but the terms of use allows it to be assigned back to you, so you will own it. It requires the user to acknowledge that the output may not be unique and that users may receive similar content. And then OpenAI, the user must also allow OpenAI to use the input and output to provide, maintain, develop, and improve its services. So you are also granting a license back to OpenAI, for example. And then there's also, you can opt out to prevent input and output being used to train models. So that's pretty good because you can opt out of something, but for the most part, it's assumed that anything you put in to OpenAI, they'll be able to use and develop databases and models off of that. So that's something to keep in mind. If you're putting in anything that's too sensitive, any confidential information, that kind of thing, you are losing control of that once you put it in there, to a certain extent. This is Midjourney's terms of service. Again, a quick summary. So the user owns the content generated to the maximum extent permitted by law. So it's a little bit different to OpenAI if you notice, but it's in substance the same. Subject to the rights of any third parties, any rights granted to Midjourney, and the rights granted to Midjourney is basically an irrevocable, perpetual, royalty-free license to reproduce, sub-license, and distribute the content. So that's the output, and the rights of others to remix the content. Sorry, I couldn't say. The user also grants Midjourney an irrevocable, perpetual, royalty-free license, as mentioned before, which means the output that you put in, you do license back to Midjourney, and they can use that for however they like. So you can't revoke that. So it's not completely without condition, but you will own the IP, but essentially Midjourney will have the rights to do whatever they want with it as well. So this is just a slide summarizing sort of the state of play for generative AI, mostly because it's a pretty hot button topic right now. In the US, there are several lawsuits underway against Midjourney. That's from a class action from artists, and also OpenAI it's under lawsuits from New York Times. So pretty high-profile cases. All of it's quite in flux right now. There's no clear determinations. The other points are just things to keep in mind when you're using any generative AI platforms. So although the terms of and use of AI can assign the IP to you, there are still some obligations there are still significant risk that the output infringes a third-party IP because you don't know where the database is coming from, essentially. You don't know how that generation that output generation is created. And you don't know if necessarily the platforms are dealing with IP in a way that's completely risk-free. There's some uncertainty as to who the owner of the IP would be, even if the output comes out from the platform. In Australia, it's pretty much accepted that a human owner will exist. So in copyright, for a human, there needs to be a human element for creation. So a person will own it, essentially. For a registered trademark, only certain legal entities can own it. So an AI platform is not a recognised legal entity, per se. And then for patents, it's now acknowledged that there must be a human inventor. And that's actually, the patent element's a pretty recent development that's been acknowledged from the IP Australia. So that's actually been confirmed. So the terms and use of an AI tool may allow your input to be used in various ways, but it might end up becoming a part of the greater output in the database. And this is one of the greatest sort of risks for a lot of artists or people who don't want their works or information to be sort of held and then regenerated as part of like a greater database, because it does mean you lose a bit of control as to what you're putting in there. So if you're putting anything any super confidential, anything very sensitive, or anything that you don't want to be repurposed or reshared, this is something to consider. And so AI tools may have been trained by open source code. I think notoriously right now there's a great question as to how AI tools are being trained. So it's not particularly clear just yet to anyone or how they're being trained and what kind of data and where it's sourced from. So if it does involve open source code, then it may be subject to the same open source requirements that we described earlier. So these are all elements to think about when you're thinking about using generative AI. It's a great platform and tool for sure for creatives and developers and whatnot, but at this point in time, it's still a developing area. So the law is still developing and also just the ethics around it is still developing. So that's basically our presentation and all the content of our slides. So we'd like to open up to any questions. If anyone's got any thoughts, feedback.
Only good feedback, probably, while we're standing up here.
So I do have a question regarding a couple of slides ago when you were talking about AI under Australian law. There has to be a human element of creation.
Yep.
Just based on the lawsuits and the arguments from other countries where those class action lawsuits are happening, under Australian law, are you saying that because someone has entered in a prompt and generated an image that prompt constitutes human creation, or is that not the case?
It's kind of up in the air at the moment, so that's a bit of an issue because when you put in the data as the human prompt, let's say you type into Midjourney, create me a picture of a dog, you have created the create me a picture of a dog, but it's the AI that has created the picture of the dog, and the AI is not a person.
Yeah, but under copyright law in Australia, for someone to own copyright, they have to actually have a human element to it. So it might not have any copyright, whatever's been created.
So that part is still ambiguous?
That's the ambiguity, yeah. And then a lot of the US lawsuits and whatnot are actually about infringement. So when it comes to AI, there's kind of two different elements, being that one is the actual reproduction element, and then that being infringement, and the other is who owns it. So the ownership is up in the air right now, and the determination of infringement is what a lot of the US lawsuits are about, because in order to have an output, it means they must have found the IP somewhere, and it also usually means that they've reproduced it, which is an exclusive right. So that's the basis of most of the US ones.
Sorry, I missed one else with the question, but with the US decisions, if they make decisions around this, would Australia generally follow suit?
That's hard to say. That one, it's pretty unclear.
I think it's probably likely that they would, but it might also be that someone has to test it as well. So someone has to actually bring a claim. But I would expect that if the US decisions are in favour of the artists that are bringing the claim against the AI, that then in Australia, artists whose work is also subject to those things will be bringing claims as well. But again, those claims are probably more likely to be brought in the US because the AI companies, the big ones, are not here in Australia.
Great, yep.
How do you differentiate between hiring a contractor and commissioning someone to do the work, art or sound or something? Early on, obviously the result is different in terms of who wants to be IP.
Yeah, generally speaking in Australia, it's usually via a contractor. So if you're paying someone for services, and paying them for like an output, for example, it's typically speaking a contractor. Commission is... Do you want to get
It's
into
probably
commission?
more where you're directing something. For example, if I say to you, you, a painter, I would like you to paint a portrait of me. I want it to be X, Y, Z. You specifically paint a portrait. So that's a commissioned work. Whereas a contractor, you might say, create me music for this game.
Right.
And they will create whatever it is they want. You might have some direction, but it'll be a little bit different.
Thank you.
Yeah.
Do you represent a lot of people that believe that copyright has been infringed? And if they do, is there like a commonality? What's the biggest mistake is the question really.
We definitely do have a lot of disputes about copyright infringement, that is for sure. Commonality-wise,
I guess the biggest mistake would be that either the person infringing has not realised that copyright laws exist or that they're not doing the right thing, or in the case of the person whose work is being infringed, that perhaps they haven't tied up all the rights properly.
yeah, I would probably agree that it's the tying up the rights element that can cause a lot of confusion. For example, they might have thought to give a partial license, for example, but that person who's infringing has done more than what they're allowed to do. That can be quite a common one. So there's been a conversation about, perhaps having a license or this intellectual property, but where the dispute comes in is if someone goes past that and someone wants to revoke that license. I probably feel like that's probably more one of the common ones. Yep.
Where do algorithms fit into the three different aspects? Is it a copyright? Or is it a patent?
If it's like coding, generally speaking, it's literary work, so it's copyright, but patents can also come into play as well.
If it's not coded, it's just written down as an algorithm on itself.
That's a good question.
It's a good
I
question.
don't know the answer to that question.
Literary work would apply, certainly, but
Yeah.
it could also be the case that it's patentable.
Because if it's written down, it may have the substance to be a literary work.
Yeah, but a patent, it still might be patentable if it's got enough inventive, requirements and whatnot. So,
An algorithm can also be derivative of somebody else's work. So somebody has defined it in a paper, which is then converted into code. So where is the rights line?
So if the original work was protected by copyright, then that first work will be a copyright work, and then the second work, which is the derivative, it will incorporate that first copyright work, and then it creates a new copyright work, but it would still need to have the necessary rights to incorporate the first copyright work. So whether it's an algorithm or like an image that you're putting into your game that's someone else's image, it's the same concepts will apply.
yeah.
If a software provides like sample sounds, like a music creation software provides sample sounds, and they say in their thing that you can use whatever you create, however you want, do you have to check where they got those sample sounds from, or can you just assume that they got all the necessary rights?
That's a good question. Ideally, you'd want to check that they have the necessary rights, but I mean, that's not really practical to do. But what you would ideally want to do is check to see if they granted a warranty as part of that license that said, we warrant that we have all the necessary rights to grant you the rights that we're granting. That may or may not be in those terms, and that's not in their best interest to include that. But sometimes they will include those terms just to show you that they're legit and they've done it properly.
Yeah, I guess for also a little bit of clarification, warranties are basically promises, but they're quite stringent promises in a contract. A whole contract is made up of promises, and warranties are kind of the most important one. The most important one. So that's just a bit of context there. So if you can't check, see if they've given you a warranty. Hopefully they have. Great, I think... Oh,
And last one, specific to generative AI, if I use an extract from a book to define a character or something, which is used by one of the tools to generate that art, am I infringing the book's copyright with an image which is not necessarily an exact definition of what has been described in text? So I'm kind of, the prompt that I use, can it be an intellectual property when I'm generating text or image?
I think it would probably depend, because for there to be copyright infringement, a substantial amount needs to be copied, and what's substantial varies depending on the specific thing. So for example, one still shot from a 90-minute film may not be infringement, but a 10-second snippet of a song might be infringement. So it really depends on the quality of the specific item that's been reproduced.
I should probably put this disclaimer in, might be a tiny bit late, but none of this is legal advice. This is not legal advice, this is just a talk. But thank you for the great questions. Great.
All right, then we might wrap it up there then.
Thank you. Thanks, everyone. Oh, just a reminder, this is Amanda Mason and I'm Isabel Wang. So if you want to find us and chat later, we're going to be around for the next 3 days.
Yep, and if you want to take a photo of our email addresses or go to our website or whatever, you could find us. Feel free to contact us anytime if you have any further questions.